Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. I'd like to begin by welcoming the students from the University of Dubuque. Could you raise your hands? Thank you. And I understand you're a criminal justice class? Great. Well, you'll be possibly more interested in the second argument then. So we have two oral arguments today and also a non-oral case in Ray, the marriage of Jonathan Sprague and Lenora Sprague. That case is now submitted without oral argument, and we'll hear oral argument in CMT Highway versus Logan Contractors. And normally Chief Justice Christensen would be seated here. She is has been at a conference of Chief Justices that was unfortunately scheduled in a way that overlapped it, but she needed to be there. She will be participating in this case and all the cases today. She will watch the oral arguments and we'll all conference them with her input. But unlike the rest of us, she hasn't figured out how to be two places at once. I also understand there's been some live streaming issues that may be internet related. So if you go back to your offices and people say, hey, I tried to watch, but I couldn't, be assured that our recording is working and this oral argument will be posted on YouTube in a few days. And with that, counsel for the appellant, Ms. Parker.
May it please the court, counsel. This case is about a $300,000 breach of contract, but Logan Contractors sought and was awarded more than 4 times that amount, over $1.2 million. That's because the district court and the Court of Appeals instituted a bright line rule that parties seeking substitute goods for purposes of cover under Iowa's UCC cannot secure those substitute goods from the breaching party. The Court of Appeals went on to say that even if that rule is wrong, a party seeking to mitigate damages need not accept cover if that cover comes with a rebate, because a rebate constitutes a surrender provision. Both rules are new, and both rules should be overturned. Beginning with the Court of Appeals holding regarding the rebate, giving, as we have to, the district court's factual findings deference, it's clear that no party understood that the October 27th, 2021 email included any type of surrender provision, nor did either party understand that the rebate offer constituted a waiver of any type of claim or defense. That much is obvious from the plain language of the October 27th, 2021 email. Nowhere in that email does it say surrender, forfeit, waive, give up, settle. Those words are wholly absent. And that makes sense because, to take a step back, the breach had been established based on the district court's findings based on that very email. Now, to be clear, CMT maintains that that email was not a breach and maintains that finding that email to be a breach worked a manifest injustice in the way that this contract was interpreted between the parties, allowing Logan Contractors to renegotiate terms at will while preventing CMT from doing so. That being said, that issue is not before the court. But by way of background, it makes sense that that October 27th, 2021 email doesn't include those terms, because CMT did not understand that to be a breach of the contract, nor did it think, based on the parties' history, that renegotiating price would be the basis for a breach of contract claim. That in mind, there is simply no evidence in the record that either party understood that rebate offer to be a surrender provision, and the finding otherwise is without support in the law. Now, moving forward to the Court of Appeals alternative holding, that the same goods cannot be a substitute under Iowa's UCC. It is undisputed that common law principles supplement the UCC unless the UCC's language displaces, a particular provision displaces those principles, or if those common law principles are contrary to the UCC's purpose. So the first question that we have to answer is, what are the common law principles that could potentially be supplementing the UCC in this case? And those common law principles are stated in Restatement of Second of Contracts, section 350, That section explains that damages are not recoverable for loss that the injured party could have avoided without undue risk.
The fact that the actual text, why don't we just start with the text of 2712, which says goods in substitution. Wouldn't that be other goods?
Clause as a whole, Your Honor, and it says goods in substitution for those due.
The official comment to the UCC, which says that the definition of cover under subsection 1 envisages goods not identical with those involved but commercially usable as reasonable substitutes. That means other goods, doesn't it?
Whole of that comment, there are three options that the comment lays out there. Those that are not identical, those that are of like kind or reasonable, and I apologize, I don't have the language at the tip of my fingers. And then there's a third option that says a contract or a negotiation, something to that effect, in substitution for the goods due, something like that. I think if you read that comment together, it's allowing a non-breaching party to expansively cover, right? It's not limiting the scope to identical goods. It's in fact clarifying that that you can cover with like-kind substitutes or a like-kind transaction.
The whole idea, here's part of it. I think, the UCC, under the common law, there was a breach of contract, you had damages, and you had sort of the lost benefit of the bargain would have been your measure. Under the UCC, the whole idea is to give to the aggrieved party more of kind of a panoply of options. So there is a market damages recovery option that is more like the common law option. But then there's cover, and cover is a separate thing, and the party has the ability to elect cover, and it seems to me cover envisages different goods that are a substitute, and there's nothing wrong with that. That's what the UCC permits, doesn't it?
Respectfully, I disagree. I think the UCC does offer the non-breaching party options in terms of their damages and remedies, but it also offers the non-breaching party options in terms of cover. And what the district court and the Court of Appeals rule does is take away one of those options. Now, am I saying that I think it's going to be commonplace that a non-breaching party wants to cover by obtaining substitute goods from the breaching party? No, I don't think that's going to be common. But do I think it should be precluded under the language of the UCC?
It kind of changed the dynamics. I mean, I can see why the UCC does it this way. They want to kind of hold people to their deals, and if your position would prevail, it seems to me that in the future, a seller can say, well, I'm not going to deliver at this price, but I'll deliver at that price. And it's kind of they can sort of play that kind of game of chicken with the buyer and force the buyer to pay a higher price, knowing that that if the buyer doesn't take that higher price, then that may be that may be the limit on the damages that they can get. And that seems to me not the way the UCC tries to do things.
I would say first that I don't believe that language of the UCC displaces the common law provisions related to mitigation. And so that in mind, it is very well established that substitute goods procured from the breaching party can be substitute goods under the restatement. And there are guardrails that are already imposed under the common law for that rule.
Have any examples under the UCC? I couldn't find any.
I'm sorry, Your Honor.
Goods being the same goods that were originally to be delivered.
I don't have any examples where a court found that the substitute good was the same good, but there are many examples where courts have left open that possibility. Many of them are cited in both parties' briefs. And when the court has left open that possibility in the context of a UCC case, for example, in Odell versus Bassaby, which is 810 P. 2nd, 1082, they applied that common law doctrine or principle that it could be a substitute, but said here it was in bad faith, right? That's one of those guardrails. And to be clear, there is no evidence of bad faith in this case. The only evidence.
Solve the moral hazard problem that Justice Mansfield alluded to, that in a situation where, the economic circumstances turn, the industry turns, costs go up, that the seller can effectively force a price increase and renegotiate the deal as long as there's some delta below the general market price. It seems like that's a real problem, and that you're giving the seller all the leverage when the production costs go up.
Your Honor, I think that concern is addressed by the pre-existing guardrails on the restatement rule. One of them being that if the offer or the price negotiation is in bad faith, that renders it inconsequential in terms of cover. That's very well established. So as I'm sure you'll hear from
Evidence of bad faith, though. I mean, if the market conditions have changed and the costs of production have gone up, maybe the seller does have a legitimate reason to want to recoup some of those costs. So under what circumstances would that not be allowed under your rule?
I think evidence of bad faith might be something like one party saying, I'm breaching the contract, sue me, I have more money. That could be evidence of bad faith. I think evidence of bad faith would be the absence of a legitimate market purpose for the requirement. And I can tell you there are probably many, many instances where there would be facts supporting bad faith. But what I can tell you is that here those are absent.
Factual question or a legal question?
Question, Your Honor. And I think that you'll hear
The district court on this.
I think you owe the district court substantial deference to the fact that there was no finding of bad faith here. And so absent that finding of bad faith, this is simply not the case where someone made an opportunistic counteroffer in an attempt to simply gain more money.
You said guardrails. Is there more than just bad faith, or is that the main guardrail that you're relying on?
The two guardrails that courts have identified are bad faith and the surrender provision. So if a counteroffer, an increased price, was made in bad faith, made simply based on an opportunistic market opportunity without what we had here, which was it was COVID, there are undisputed supply chain issues, the price of steel was skyrocketing, the district court found that CMT
Supply chain issues that caused your client to have some delay problems and delivery problems, how does that weigh into the guardrails that you're talking about?
evidence that CMT was not acting in bad faith in a way that was opportunistic just because they could.
Logan has to take your offer with the delay problems that you had had, the production problems that you had had?
They have to. It means they should have the option. And that was an option that was foreclosed by the district court and the Court of Appeals. Now, whether keeping that option open, it was still reasonable for Logan Contractors to choose a different good to cover is a fact question. And that fact question is most appropriately addressed by the district court. But here,
On that question,
the question of whether it was reasonable with the substitute goods from CMT being an option was not addressed. There is no fact finding on that question to defer to. That's a question that would have to be answered by the district court in the first instance. Because when the district court did the analysis of reasonableness, it excluded as even a possibility the use of CMT's substitute goods for cover.
Because it seems like the district court didn't need to consider that counterfactual situation. Isn't the ultimate issue whether it was reasonable or not what actually occurred?
Whether Logan's cover was reasonable. However, the court applied the facts in this case to the wrong law. They applied the facts to the law that said it is never reasonable or it's not an appropriate substitute under the UCC to purchase goods from the breaching party.
You're using this word substitute. I mean, like for the students here, if they had a substitute teacher one day, that would not be the same teacher at a different price. That would be a different teacher, right?
If I am booted off my flight, they might give me a substitute ticket at an increased price if I'd like to take that option, right? So there are many factual scenarios in which a substitute may or may not be reasonable.
Cases, as everybody has apparently, to see where a court approved going back to the same seller to charge a higher price at the same, for the same goods. And I don't find any, and that makes perfect sense to me because normally cover going elsewhere for substitute goods is because the seller can't deliver. If they're able to deliver the goods, why not hold them to the price they agreed to?
I think it's perfectly reasonable that in many cases, it would not be a substitute that they would have to choose. This case represents that unique case where that option should be open. And I can say I did find one case. It's very old and it's not cited in our brief. I'd be happy to supply it to the court. It's Lawrence versus Porter, and it's actually the case that forms the basis of the example 14 in the restatement. It's very old. It's 63 F62. It's from the Sixth Circuit in 1894. But with age comes wisdom, right? And I think the wisdom of that case holds true.
So substitute ticket, that would still be a different ticket. It would be, you know, in the old days when the tickets were pieces of paper, it'd be a different piece of paper. If they said, we're going to give you a substitute flight, which is what we're talking about here, substitute goods, I wouldn't think it would be the same flight at a different price. It would be a different flight, right?
If I may answer your question. I will not pretend that I know any of your Honor's travel experiences, but I can say that it's not difficult for me to envision a circumstance in which an airline says, we overbooked our flight, but if you want to pay more to get on this flight, you can do it. And that's what I mean in terms of the context around what is an appropriate substitute is going to be varied. And while CMT agrees that it is probably going to be a very unique set of circumstances in which it's unreasonable to cover with goods from someone other than the breaching party, if there is a set of circumstances, it is these.
Question, follow-up. I want to clarify one thing. You keep saying that they should have the option of covering through CMT. I think what you're arguing, though, is it's required under these circumstances. Otherwise, their damages are capped at the delta between the original price and the price CMT was offering, correct?
In this specific case, I do think it's required. However,
saying as a matter of law, they had to choose CMT, and if they choose someone else, their damages can't exceed the difference between the original price and the price that CMT set after the fact.
I disagree, Your Honor. I don't think they were required as a matter of law. I think in these factual circumstances, it was unreasonable for them to choose a cover that was 4 times the amount.
And their damages capped as a matter of law, in your view. Okay.
In these factual circumstances. What I do think should be the case as a matter of law is that an option from a breaching party should be considered in considering the universe of reasonable alternatives.
Rebuttal. Mr. Thrall?
May it please the court, counsel. The issue in this appeal is simply whether Logan Contractors' purchase of goods to cover following CMT's breach was reasonable under Section 554-2712. The reasonableness of Logan Contractors' cover is a question of fact, and that question of fact was resolved in Logan Contractors' favor by the business court based upon the testimony, evidence, and exhibits that were introduced at trial. As the Court of Appeals held, that factual determination was supported by substantial evidence in the record and must be affirmed. I also think, as the court has already focused, it's important to consider the practical effect of adopting the rule advocated by CMT. Through the guise of a mitigation argument, CMT argues that a buyer is required to renegotiate the terms of the contract with a breaching seller. The rule incentivizes a party to breach a contract whenever they find the terms to which they had agreed are not and no longer advantageous. Adoption of a rule like this would wreak havoc in the sale of goods, particularly in the paving industry, where suppliers are locked into their pricing and with contractors who are in turn locked into their pricing with the government entity for which they have a public contract. Such a result is inconsistent with both the language and the intent of the UCC. Council made two arguments in support of CMT's position. The first addresses whether the same goods can ever be goods in substitution for those due from the seller. And I think the answer to that question is in the plain text, the plain language of the section. The same goods are not goods in substitution for those due from the seller. And I think that's borne out by the language of the statute as well as the comments to that section. Again, CMT has not cited a single case where a buyer was required to cover with a breaching seller.
In Iowa, for better or for worse, we did not adopt the comments as part of the statute, right?
But I think the comments are nevertheless instructive in interpreting and gleaning what the intent was for the UCC.
The comments, then, they talk about goods not identical, but isn't that really just kind of going the other way, saying it doesn't have to be the exact same type of thing, but they have to be close enough? And so we see a lot of, like the cattle cases, they have to be cattle that are similar weight or something like that. Isn't that kind of the point of saying that they don't have to be identical?
That is the point, but here they are essentially talking about the identical goods. They're talking about the same goods. They're not talking about goods in substitution for those goods. They're trying to renegotiate and extort from Logan Contractors a higher price for the very same goods that they contracted and agreed to provide. And I think it's important, while I certainly would agree that at times the common law can supplement the UCC, it's clear that the common law cannot supplant the UCC provisions where applicable. And I think the Article 2 remedies supplant the common law. You've got a scheme under Section 2711 in which the buyer is given a variety of remedies that they can choose when there is a breach by the seller. Certainly cover is one, but they could have also sued for market price less the contract price under 554-2713. So they're not required to cover under the UCC remedies, and I think this is also important in terms of the context of interpreting Section 2712. The Lawrence v. Porter case that counsel referred to is an 1894 decision. Obviously predates the adoption of the UCC by
exercising control over stolen property, and then had him extradited to Wisconsin so that they could address the theft by taking. Although I believe our records are void that Mr. Heiller was actually the one who took the vehicles from Wisconsin.
Possible, right, that even if it's not an essential element of the offense, jurisdiction, that it's still something that's not waivable, that the court has an obligation to make sure that the state is asserting its sovereign power in this particular case, even if it's something else, some procedural mechanism, some legal issue for the court, right? I mean, having it be an element doesn't mean that courts can't look at it.
So the entire record is available for review. I did not locate evidence indicating that either element of theft by taking had occurred here.
We're talking about personal jurisdiction. This is, it's an interesting case, not something we get normally. This particular these pair of cases. Can we look at scenarios where the defendant is not personally in court, and then there's the question whether there's authority to try him or her in absentia, because that's also a personal jurisdiction issue? Can we look at some of that case law to guide us, maybe?
And I don't believe that this is a personal jurisdiction issue at all. Mr. Heiller clearly brought himself into the state of Iowa, so that shouldn't be.
It's personal, right?
And even too with I know the Court of Appeals focused on subject matter jurisdiction, which I recognize as limiting the authority of the courts, if you will, to hear certain types of cases. I don't think that this is one of those cases. I mean, the court has subject matter jurisdiction to hear all of the criminal cases. So territorial jurisdiction, I believe, is similar in the fact that it cannot be waived, but it also takes the extra step of limiting the legislature's ability to determine what actually is a crime in the state of Iowa.
That territorial jurisdiction can be raised later and cannot be waived. What happens? Does he walk on all the charges?
So he has been in custody since he was arrested on October 1st of 2023. We are not raising a territorial jurisdiction argument for the Gator. So he still has his 10-year prison sentence on that. He was recently paroled to a residential facility in West Union, so he still is in custody. But I believe that the state of Iowa, if it determines that it still wanted to charge him with exercising control over stolen property, that it would have the ability to do that. We're within the statute of limitations for those charges. Under the Blockberger elements test, I believe that it would not be a double jeopardy violation. The only thing I would need to look further into is whether or not under speedy indictment with the minutes of testimony actually alleging the exercising control over stolen property in the minutes rather than theft by taking, would that be some type of a speedy indictment issue?
With counsel not raising this below, it strikes me as maybe a kind of gaming problem where someone could not raise it, see what the jury says, and then raise it later. How do we prevent that?
So, and I believe, Your Honor, that trial counsel had raised, it's unclear in the record whether it was actually a jurisdictional issue that counsel had been raising or whether or not it was a venue issue, which is non-jurisdictional. I know that he did go ahead and raise that when he did his motion in arrest of judgment and motion for new trial.
Isn't raised.
If it's not raised, I think that we still have a problem because the state of Iowa is required to prove this element beyond a reasonable doubt and has failed to do so. So I think that you would have a due process violation. I certainly hope that attorneys would not game on you, but this is really the state's burden, Your Honor, not the trial counsel's burden.
Bring it up. Doesn't raise it as a problem at all. Doesn't that sort of put the prosecution in a very strange spot? Because in most cases, it isn't a problem. It isn't a question. It's presumed.
This is an anomaly, but I think that under the constitutional protections that are provided to Mr. Heiller in these situations, that the state should not be relieved of its burden of proving something beyond a reasonable doubt if it's failed to do so.
The state, rests and hasn't proved an essential element of the crime, or a part of an essential element. They can raise that. The defendant can raise the issue on appeal under Crawford, right? Without even giving the state an opportunity to, say, reopen their case below or try and fix it before the case goes to the jury.
So we are asking, I'm sorry, so did you have a question? Okay. So we are asking that this court reverse Mr. Heiller's convictions for the theft by takings, remand them to the district court for dismissal. Thank you.
Ms. Trout?
May it please the court, and for the record, Your Honors, I did file an appearance as I will be handling both of the cases today, arguing both. I think the defendant attempts to shoehorn a sufficiency challenge into what should probably be a case involving instructional error. At the district court level, there were no objections made to the jury instructions regarding the territorial jurisdiction element. And as the court has held on many occasions, that an instruction given, whether right or wrong, becomes law of the case. So this court, when looking at a sufficiency challenge, needs to look at what the jury was instructed on in reaching its decision. And notably, there is no requirement in element 1 that the crime occur in Alameda County, as well as the language regarding intent mirrors the statute, but it is not a correct interpretation as this court has interpreted an intent to deprive under State versus Schminke. So when we look at whether or not the court, there was an element of territorial jurisdiction, under State versus Liggins, this court has found that, yes, it is an element that has to be proven beyond a reasonable doubt. And while it is not contained in this particular instruction, if the court then deems this non-waiver of the territorial jurisdiction to be something that can be raised at this late date, inexplicably, I don't know why this wasn't caught either at the charging or at jury instructions or in motions, but it wasn't. And we're here to...
I thought it was raised in the 1069 case by motion and arrest of judgment.
At that point, it's too late to correct anything. I mean, ideally, it would have been caught in a motion for a judgment of acquittal at the close of the state's case. And then something could have happened, which would...
Was that just the venue that was raised at the end of the state's case? It wasn't the territorial?
Be clear, but to the extent that something was raised, if it's not clear, then how can the court address it? And it might have been venue, which then could be waived, just...
And, you know, what's so unfair to the state here? I mean, it was sort of kind of clear all along that the vehicles disappeared, you know, on the Wisconsin side of the river, right? So, I mean, and you're charging, you know, Mr. Heiller with theft. I mean, isn't that, you know, I mean, that doesn't seem that difficult. That would seem to be something that would cross the mind. Maybe, I'm sure it would have crossed the mind of Ms. Chapin back when she was prosecuting up there. So, you know, what's so unfair? You know, we've said in Rimmer that territorial jurisdiction can't be waived, and so you can't, you know, go ahead. I'm sorry.
Interrupting you. Theft is a weird crime. If you look at it, we have one offense of theft. We have multiple ways of prosecuting or charging that case. In Hogriff, you said theft by deception and theft by check are overlap. There is some overlap because theft by check is a specific form of theft by deception. In the context of a theft by taking and exercising control over stolen property, ordinarily you would think that it's a spectrum. So initially an offender would take the item, and at that point, because we know it's not a continuing offense, the offense begins and ends. If the state's not able to establish that taking, then we have that fallback of exercising control. But when Ms. Chapin was talking about this as a conduct offense, that the actus reus and the mens rea occur at the same time, this is a problem that I think we have with Schminke. Because when you look at it...
Ask you to address it. Also, I think you agree that theft is not a continuing offense. As you're discussing Schminke and that concept, what about the Amvok?
I think that it seems to me as a lesser included offense, because Amvok is the only true lesser of in a theft prosecution. I think that the possession would satisfy because when we look at our statute now, as it was modified in 1978 by adoption of the Model Penal Code. In State versus Null, this court said, you know, we took out that taking, and the emphasis now is possession, because we've also removed asportation from the crime. So I think that it is the possession of that vehicle without the intent to permanently deprive. I think
that the defendant gets into a car, that's a new offense. So if a defendant, let's say the defendant's stolen this car, they wake up Monday, they drive it around, that's possession of the car without consent. Tuesday's a different offense, Wednesday's a different offense. How do we slice that up?
Your Honor, I think that, as I said, there's, like, when you look at one offense of theft, if Heiller is still good law, which there hasn't been any indication that it's not, if Heiller is good law, that you can take that incident, or you can take that vehicle or that property once. And so it wouldn't necessarily, I don't think that we would, you wake up on Monday, that's one offense. You wake up on Tuesday, that's another offense. Oftentimes, because vehicles are transport, that they go and you're not necessarily certain when it was taken or how many days. It's just, maybe when the owner realized that it was gone and or when that person had them in possession. But getting back to that conduct, the mens rea and the actus reus, I think Schminke is understandable how the court decided that there has to be this intent to permanently deprive, even though that's not set forth in the statute. Looking at Schminke saying, well, there has to be a difference between the operating without the owner's consent and that theft by taking. And this is that intent to permanently deprive. And looking at Schminke, which was a case involving an Alford plea, the defendant pleaded on the minutes, and there wasn't necessarily that much evidence relative to what the defendant's intent was at the time that he took the car. So then the next case is State versus Morris. And in Morris, a man goes out to start his car, goes inside to pick up his wallet, comes back outside, and his vehicle is gone. So he reports it stolen. Law enforcement then is able to catch up with that car after a short time, maybe 30 minutes. And the car is then, ditched. And the court found that, well, it's possible that you had an intent to permanently deprive, but that there's a very, very short window that you would be able to establish this. My point is that if you have to establish that intent to deprive in just that slice of what the time that the offender took the vehicle, and we can't use anything after that fact, because what happens after that fact is incidental to the actual taking, then it is impossible for the state to determine that intent to deprive. And what we assert is that when you look at 803.1 and we have that long arm provision that if it's conduct or a result occurs in Iowa, then we should be able to establish that. So I think that when you look at State versus Ernst and the ability to use the stacking of inferences, that yes, we do have to establish that the defendant had the intent at that time, but the state should still be able to use conduct after the fact in order to establish that. And I think that that has been the problem with the interpretations following Schminke and following Morris, that the state has locked in that you have to prove it at the time, and that theft is not a continuing offense. But
Evidence after the fact, and evidence even that occurred in Iowa, could be relevant to establishing the intent at the time of the taking. So in the case involving the Tiguan, I think the car is reported stolen, and then the defendant's found in possession of it a couple days later, I think. Yeah, next day. So very kind of close temporal connection. But that doesn't mean that the elements occurred in Iowa. It just means that there's some evidence that might be relevant that was obtained in Iowa. I mean, there is a distinction in terms of territorial jurisdiction, I think, right?
I also think the fact that it was outside of the jurisdiction, it was outside, the car was driven to another state. I think that should be a relevant inquiry for the jury to decide what his intent was at the time that he took it. I understand that that temporally that might be a more difficult thing, but I think that we just need to allow the juries to make these inferences. Plus, when you look at what the police power, the whole basis of territorial jurisdiction is the state's police power and whether or not the legislature can make that determination as to what a person's conduct is when they're in the state. And I genuinely believe that the state has an interest in being able to prosecute people who are operating stolen vehicles within the boundaries of the state.
Charged, right? Operating a stolen vehicle, that could have been charged, but it wasn't.
That's true. That is true. And that's why if you are to find that this case should be reversed, it shouldn't be reversed for a dismissal. It should be reversed in order to give the opportunity for a jury to make that determination relative to jurisdiction.
Cases are correct, and jurisdiction is an element of the offense rather than, or at least an essential element. I know some other states say no. Then acquittal would be required.
Disagree, because again, you have to look at this case through the lens of the law of the case. And when we have those law of the case, if the instruction is wrong, if the instruction is lacking a material element, which clearly if you find, your cases are right, the material element is that element of territorial jurisdiction.
And on these two cases, the state concedes that territorial jurisdiction is not waivable. Do you agree that it's not waivable?
Yes, for that reason, I think that it's still, if it's not waivable, I think that provides the hook for this court to consider this, but not as a sufficiency, because what the sufficiency has to be based on how the jury was instructed. So I think that the hook is that the jury instruction is wrong, and we would admit that there is no element of territorial jurisdiction in these. So we remand for a new trial.
Kind of square that with the Court of Appeals holding that error wasn't preserved. So, I forgot, I'm actually trying to remember the Court of Appeals disposition. I thought it was affirmed.
Was, Your Honor, but I think that when you have to, my problem, and I understand that it was only Judge Tabor that had this, I'm not at liberty to say that in a Liggins, when the court says that territorial jurisdiction is an element, is an essential element, it has to be proven beyond a reasonable doubt, it's not waivable, I think I'm bound by the court's precedent.
If you were writing on a blank slate, there are other jurisdictions that treat this question differently. Some say it's a non-essential element that needs to be proved when it's disputed. Some say it's a question of law for the court. Some say you can give a special interrogatory to the jury and then the court can make a ruling on it. How would you approach this on a fresh slate?
I think that I would consider it that if it's not objected to, then it has been waived, recognizing what the holdings of the court's cases.
Go by what we said in Rimmer as opposed to the earlier cases that treat it more like an element, like Liggins. Is that, because it is troubling the notion that. But at the same time, it's troubling the notion that the two parties can agree to have a case tried in Iowa, or by not raising the issue. And what if not like here, the case really had nothing to do with Iowa? That seems to be not right.
One of the cases, the 169 did, 170, right.
There was some connection to Iowa in both cases. I understand.
Your Honors, we would initially request that this court affirm, as the Court of Appeals did, alternatively remand for a new trial.
Chapin.
I think it's important to clarify that Mr. Heiller was not charged with stealing the automobile. That would be a matter for Wisconsin, since that was the place where the theft actually took place. Mr. Heiller was charged with being in possession of stolen property, which was the prosecutor's statement to the court when the prosecution was defending against the motion in arrest of judgment, right? So here it's clear, and I understand that we're going down a few different avenues. I think it's clear that the state truly intended to charge him with exercising control over stolen property. The trial information in the charges, they were labeled possession or control, but then the theft by taking information had entered that. When the state indicates that this should not be reversed for dismissal, but should be remanded for a new trial, if this were remanded for a new trial, we'd have a double jeopardy issue. When the state fails to meet its burden by proving all of the elements beyond a reasonable doubt, and the court determines that, then you have a judgment of acquittal. This is a dismissal, right? This does not keep the state from charging Mr. Heiller with the theft via 714.1 sub 4, in that he can still be charged with exercising control over stolen property, which is what I think that the state had intended to do all along.
Though, is gauged against what?
So it would be gauged, sir, based on the entire record. If there's any type of substantial evidence supporting that one of the elements occurred here, then we would have territorial jurisdiction.
What we look at for that, right?
Yes, Your Honor. In this area, or in these cases, I believe that when you look at just the instructions themselves for corrections of errors at law, if the record actually had the information in it and had the evidence in it, I think that this would be harmless error. But since the record is void of any evidence that the theft by takings occurred, at least in one way or another here, I think that's where it's the biggest problem.
But the thought that the territorial jurisdiction statute is supposed to define the universe of crimes that the state has invoked its sovereign authority to punish. In some circumstances, it's even asserted the authority to punish crimes occurring wholly outside the state of Iowa, not relevant here. But if we think our theft statute is one offense with a lot of different alternative means to commit it, if we agree that theft by possession of stolen property would apply here, and that the state as sovereign has asserted its authority to prosecute that kind of offense, maybe it's a different kind of problem that could be waived, right? I mean, I think you're agreeing that if they would have charged theft under 714.1 sub 4 for possession of stolen goods, that we wouldn't have a jurisdictional problem.
And you wouldn't have invited me to come hang out with you today. Yeah, I wouldn't be here. That's absolutely correct.
The same offense, which is theft. So if we have jurisdiction over the theft, does it really matter what the jury instructions were for the purposes of territorial jurisdiction analysis?
Matter, Your Honor, under State versus Null and State versus Williams, when the court recognizes that there are 10 different alternatives for theft that the legislature has provided. And further, if theft by taking was the same as exercising, I'm sorry, I always want to say possession of controlled substance because I was a drug prosecutor, but exercising control over stolen property, because they are separated by the legislator and made two different offenses with two different types of intent and things of that nature. I don't believe that we're splitting hairs on this at all. I think that the state just failed to meet its burden. They charged him improperly, and they can still remedy that if that's what the state is wanting to do, but not by remanding this for a new trial in a double jeopardy violation. In order to uphold Mr. Heiller's constitutional rights, they would have to then recharge him. And so because of that, we are asking that his convictions be reversed and remanded to the district court for dismissal. Thank you.
Cases 240169 and 0170 are now submitted on State v. Heiller. Again, thank you. The court is adjourned for the afternoon.
Take care. Visit.